Okay, good morning, everybody. I'm Judge Montalvo. I'm going to be presiding over these hearings this morning. We're set for bench trials. Okay, let's see here. We'll take up the state of Texas versus Nicolas Arteaga. Mr. Arteaga, you here? Good morning, sir. Okay. We also have the state of Texas versus Alfredo Cuellar. Mr. Cuellar, are you here? You can have a seat. Just want to make sure you're here, Mr. Cuellar. And then we also have the state of Texas versus Daily Dives. All right, so everybody's here, good. Before we get started, everybody here is requesting a bench trial, and that's how we're going to proceed, which means everybody here will be requesting a trial before the judge alone. So your arguments will be presented to the court, and the court will ultimately decide whether or not the facts support the allegations made against each and every one of you this morning. Before we get started, are there any announcements, Ms. Orego?
No, Your Honor.
Okay. I understand that there are, I think on one of these cases, we need an interpreter, is that correct? Which one is that? Is that Dives, Cuellar, or Arteaga? Do we know which one is in? Dives? All right. And we don't have one this morning. So, Ms. Dives, are you Ms. Dives? Good morning, Ms. Dives. Español, prefiere español, ¿verdad? Señora Dives, disculpe, esta mañana está asistido usted para una audiencia, obviamente con el juez. Desafortunadamente no tenemos el intérprete. Pues obviamente se va a requerir para que usted pueda seguir con el caso, ¿verdad? La única manera que podemos hacer esto, no la única manera, pero la manera que vamos a seguir es vamos a tener que citarla para otra audiencia, porque no está el intérprete disponible hoy esta mañana. Tiene que ser alguien certificado. No podemos, a mí yo lo puedo hacer, pero yo hablo español, pero no sé. El asunto no es quién habla español, el asunto es quién está certificado para interpretar en una corte, para poder, porque aquí la corte es de archivos, o si usted quiere apelar el caso, usted tiene ese derecho, y tiene que ser alguien que obviamente está certificado para interpretar y no alguien que está usando tú sabes, disculpen, no tenemos ese intérprete disponible esta mañana, vamos a tener que darle otra cita para otra audiencia. Borrego, is that about right? We don't have an interpreter, so I'm going to reset this for another.
State has no objection, Judge.
Okay. So we reset bench trial to obtain a translator. No, disculpe, señora, yo sé que también usted tiene prisa para terminar con esto, pero tenemos que hacerlo propiamente, obviamente, y vamos a citarlo lo más pronto posible para poder que venga para atrás y arregle esto lo más pronto posible. ¿Ok? ¿Alguna pregunta, señora Dives? Ok, gracias por venir esta mañana y de nuevo disculpe, ¿ok? Gracias. Ahorita le dan la fecha nueva. Gracias. Okay, and then the next one here we have set is Mr. Alfredo Cuellar. Was there anything we had to take up with Mr. Cuellar?
Nothing from the state, Judge.
No. So we're ready to go, Mr. Cuevas. Okay. Okay. And then Mr. Arteaga. Okay, so let's go ahead and we'll call this one first. Mr. Cuevas, just hang in there with me, be patient. We'll take up Mr. Nicolas Arteaga's case first, and then we'll hopefully be able to get yours out of the way as well. Okay. And so the state will call, the court will call the state of Texas versus Nicolas Arteaga, cause number 2428378. And I believe it's just it's a no building code permit, no electrical code permit, no mechanical code permit, and construction without inspection. Those are the three allegations made on this complaint. All right. Before we get started, is there anything we need to take up? Any pretrial motions?
None from the state, Judge.
Okay, Mr. Arteaga, anything we need to take up before we start?
No, sir.
Okay, all right. There is. Okay, Mr. Arteaga, because you are proceeding what they call pro se on your own, you're representing yourself. You need to be aware of certain rights that you have as an individual. You do have the right to be presented by counsel. Of course, you have the right to proceed by your own. Because you are waiving the right to a jury trial, the court's going to ask you and require you to file what they call a waiver of a jury trial. In other words, I'm going to advise you, and you're going to hear me repeat myself over and over again about how you have a right to a jury, you have a right to an attorney. But though it's only because you need to understand that you're going to be held to the same standard as Ms. Borrego and any other attorney, regardless of whether you're licensed or not. The rules are going to apply to you. The requirements and conditions of evidence are going to apply to you. So this isn't going to be like TV where I have a picture I want to show you. That's not the way it's going to work. You're going to have to set the foundation for that in order for it to be admitted. You have the ability to object to it and things of that. And that's why you're going to hear me repeat myself over and over again, that you have the right to counsel and that you have the right to have somebody represent you. So before we get started, let me read this to you. This is called a waiver of a jury trial. I'm going to read this out loud, then I'm going to hand it to you, and then you can review it yourself, and then you're going to sign this, understanding that you're waiving a jury trial, and we'll hand it over to the prosecutor's office. If they agree with it as well, they'll sign it, and then we'll have a record of it. Just so you're aware, this is a court of record, so everything right now from here on out has been being recorded. Whatever the results may be, if you intend to request an appeal of the results here, you have that right also. But before we get started on anything else, let me go ahead and read this waiver of a jury trial, okay?
Could I turn in this document?
You see, that's not the way it's going to work.
Okay.
That's why I'm saying you're going to be held to the same standards.
All
In a
right.
courtroom, we just don't I know, Judge, I have a motion here, or I have a paper here that I want to show. No, that's not the way it works on TV and in the movies, but not in a courtroom. So I'm going to take up the preliminary matters first, which is to advise you of the fact that you have a right to counsel, to advise you of the fact of the consequences, of potential consequences and hurdles that you have when you represent yourself. When we're done with that, we've agreed to that, you've signed off on that, then we'll take up any preliminary matters, okay? All right. So on the waiver of jury trial, it reflects, it comes now the defendant in the above styled and numbered cause and states to the court that the defendant has been advised of the constitutional and statutory right to trial by jury in this misdemeanor case. He understands that right and knowingly and intelligently, voluntarily waives trial by jury and elects to proceed before the court. Texas law permits a defendant in a criminal prosecution other than a capital felony case in which the state seeks a death penalty to waive trial by jury if the waiver is made by the defendant in person, in writing, in open court, with the consent and approval of the court and the attorney representing the state. In misdemeanor cases, a plea of guilty or no contest may be made either by the defendant or by counsel in open court. The defendant would respectfully show the court the following. The defendant has been advised of the right to a trial by jury in this case. The defendant understands that if a jury is not waived, a jury selected according to law would hear the evidence and determine guilt or innocence, and where authorized by law, punishment. The defendant understands that, that by waiving a jury trial, the case will be tried to the court and the judge will hear the evidence and determine guilt or innocence, and where authorized by law, punishment. The defendant has had sufficient opportunity to consult with counsel, if represented, regarding the right to a jury trial and the consequences of waiving that right. The defendant states that this waiver is made personally, in writing, in open court, knowingly, intelligently, and voluntarily, and is not the result of force, threats, coercion, or promises apart from any plea agreement, if any. The defendant requests the consent and approval of the attorney representing the state and of the court to waive a trial by jury and proceed before the court alone. That is the waiver of a jury trial, Mr. Arteaga. I'm going to now hand this over to you so you can review it yourself, okay? And then once you've reviewed it and signed it, pass it on to the prosecutor, please. Oh, okay, so it's not you, it's him. Okay, all right. right,
I wanted to explain that before you started talking, but you started talking, so I was gonna let you finish, of course. But I was gonna explain that I'm his son, but I was also a manager.
Who's being charged here?
Him.
All right.
I'm a manager at the restaurant that he owns, and he's being cited for
I understand the citations. I have them all here. Yes, sir.
but they gave me the ticket because I was the one there.
Okay.
So that's why
I'm the one responsible.
yeah.
Yeah, the citation is issued to the individual acting as an agent of the employer. So regardless of who owns it, if you're an employee there and you're issued a citation, you act as an agent of the owner. So the citation is still issued to the individual, regardless of whether or not you own it, whatever it is. At the end of the day, anybody who acts on behalf of or is there on behalf of the owner or manager or whatever acts as the agent of that person. So the citation, if you're trying to say, well, I have nothing to do with this, I just work there. Unfortunately, as an employee, you act or take position of, or you're in a position as an agent of the entity. All right. So I don't know if that's what you wanted to clear up, or that's what you're trying to.
That, and also I have really like nothing to show. Only he does. That's also what I want to point out.
Okay, I don't know what that means. Like I said,
every-
we're gonna hold you to the same standard. This is gonna be a court proceeding. We're not gonna we're not gonna have a conversation, in other words. This is gonna be a court proceeding. We're gonna start the trial. You're gonna present evidence. The prosecutor is gonna be able to also present evidence. You can cross-examine witnesses and things of that nature. I'm not trying to be rude, but that's why I say, if you're gonna come and represent yourself, you gotta understand, nothing changes for anybody here. Everybody here is gonna be considered at the same level of competency with regards to the law, even though you're not. I know you're not. I know you didn't go to law school. I know you're not an attorney. But at the end of the day, you have the right to represent yourself. You do.
Yes, sir.
But you just got to you got to understand that I can't give you a chance just because Ms. Borrego has 20 years of experience and you don't. You know what I'm saying? So that's why I'm saying we're not going to have a conversation about, well, this is what happened. before we even start the trial. We're going to start the trial and you're going to have a right to explain all of those things to me.
I'll let that get to like, of course, when that happens. I'm not gonna like explain now. All I was trying to make the point is that when you're gonna be talking to me, I'm not gonna have any evidence to show. He's going to have all the evidence and he's the one that's gonna have to talk for me.
But that's my point, that it doesn't matter to me whether you have anything to say to me. You're not going to be, in other words, I'm not going to be having a conversation with you. You're going to be presenting evidence. So regardless of whether or not you have anything to share with me with regards to the circumstances surrounding your citations.
I'm basically saying that he's gonna be representing me because I have nothing to.
No, there's nothing there's nothing in the court that indicates that you're being represented by anybody other than yourself. There's no notice here that says in counsel's place or, in place of counsel, X, Y, or Z is representing me on my behalf. There's nothing here. I don't have anything filed. Nothing's been filed on that.
I
So
think I don't have anything else to add then.
that's fine. I'm just telling you what it is.
Yeah, no, that's okay, yeah.
Okay, man. All right. Are we ready? Review that document, sign it, pass it over to the prosecutor's office.
Right here. And then I print my name as well. Yes, sir.
This week, we turn in the beginning of the week, but they all these, we get sent an email. That the prosecutor will. To the city. But was talking, they said everything was from very good. Everything, for the citations, we turned this to the prosecutor already. Okay. There's nothing we can do.
I figured that's what.
All right, thanks.
So I just said that we turned all this into the city already.
Okay, let the record reflect that the waiver of jury trial has been signed by both parties and has been admitted to the record. All right. So let's go on. Once again, the Municipal Court of Record in the city of Mcallen is now in session. The state of Texas versus Nicolas Arteaga. Okay, I can take appearances, please, from the prosecutor's office.
Appearing for the state, Your Honor, is Norma Borrego, and the second chair, Chad Toller.
Okay. On behalf of the defense, announcements, please. Appearances. Okay. All right. Okay, let the, go ahead, Mr.
Your Honor, respectfully, before we proceed, I know that Your Honor has already cleared up the fact that the defendant is not being represented by counsel. However, I would ask that the court admonish the person sitting with Mr. Arteaga, the defendant, that he is not allowed to address the court or ask witnesses questions or present evidence in this case.
Correct. We'll take that up as soon as, yeah, we'll take that up as soon as I'm done with all the preliminary matters, but we'll address that in a minute. All right. Okay, let the record reflect the defendant is present in court and is announced ready for trial. This is a bench trial, a non-jury trial, and a written waiver has been filed. Mr. Arteaga, you have a right to a trial by jury in this case. A jury would consist of 6 citizens who would decide whether you are guilty or not guilty. Do you understand that right?
Yes, sir.
Okay. Do you wish to waive your right to a jury and have me as a judge hear the evidence and decide your case?
Yes, sir.
The court has received a written waiver of jury trial and let the record reflect that the defendant knowingly and voluntarily waives jury trial, and this matter will proceed as a bench trial. So there are a total of, there are 4 charges here. The first one is a no building code permit. Second one is a no electrical code permit. Third one is a no mechanical code permit. And the fourth one is a construction without inspections on a commercial property. You are charged with these offenses alleged to have occurred on or about the 28th day of December 2024. These offenses are punishable by a fine not to exceed $500 plus court costs. In this trial, the state must prove each element of the offense beyond a reasonable doubt. And before I can find you guilty, you are presumed innocent unless and until that occurs. You do have the right to be represented by an attorney. You have the right to remain silent. You do not have to testify or say anything. And your decision not to testify cannot be held against you. You have the right to confront and cross-examine the witnesses called by the state, and the right to call witnesses in your own defense, and the right to subpoena witnesses to court. Mr. Ortega, you also have the right to have an attorney represent you. You do understand that if you cannot afford an attorney in this municipal court of record, there is generally no right to court-appointed counsel in fine-only cases. But you may hire an attorney at your own expense. Do you still wish to represent yourself and proceed without a lawyer?
Yes, sir.
I must advise you that representing yourself is risky. You'll be required to follow the same rules of procedure and evidence that licensed attorneys must follow. I cannot give you any legal advice or tell you how to present your case. Do you understand that the prosecutor is an experienced attorney and that unfortunately your lack of legal training may put you at a disadvantage in this particular scenario? Do you understand that?
Yes, sir.
Okay. Having heard these warnings, do you still wish to give up the assistance of counsel and represent yourself? You still want to go proceed yourself?
I think it'd be best to get a lawyer since I'm the one being charged for this.
Okay. Borrego, Mr. Arteaga has, although the waiver of jury trial has already been signed and admitted into the record, Mr. Arteaga still has a right before we begin proceedings to request counsel, which he has. Of course, the state has the position also of objecting to that because we've already started the proceedings, but Mr. Arteaga has requested more time to obtain counsel. Any objections?
Yes, Your Honor, state does object. This case was filed on January 16th, 2025. That's more than a year and a half that Mr. Arteaga had to retain counsel. Secondly, the defendant has made absolutely no effort to reach out to my office to try to figure out how this issue could be remedied. Therefore, at this time, Your Honor, respectfully, we object.
Okay.
Your Honor, I believe we have tried to make, at least I don't know about contact, but at least comply with some. I remember the last time we were here, Judge made us do a couple of things and we had a couple of things taken care of. We have a couple of paperwork right here. I believe we turned them into the city, I believe,
No.
this past week.
Okay.
I believe there was also an email sent to the prosecutor, I believe,
Send me copies of the we comply with it.
or sent to the city telling them that we complied with everything. I apologize.
Okay,
And the prosecutor was copy of that prosecutor was on that email.
And the prosecutor was also on that email.
all right, so this is what we're gonna do, Mr. Arteaga. I'm gonna go ahead and reset this for 30 days or as soon as possible, because it has been a long time. I'm gonna let you go ahead and retain counsel, get your attorney lined up. And then we're gonna take this up. So as far as discovery and things of that nature, that's already been done, because you're already here at the point where we're gonna start. So whatever you have, whatever you receive from the prosecutor's office, you'll just hand that over to your attorney when you hire your lawyer. And then we'll set this one more time for a pretrial hearing. And then we'll set it for the bench trial. That way your attorney has time to file any pretrial motions if they want to do that, and then we'll set it for the bench trial.
Yes, sir.
But yeah, that's, I mean, that's your right. You have a right to counsel, so you can proceed that way. All right, any questions? All
No,
right.
sir.
Whatever, anything from the state?
No, Your Honor.
All right, okay, so we'll be resetting this for 30 days, more or less, for a pretrial hearing. Thank you, Mr. Okay.
Yes, sir. Thank you.
Sure.
Yeah, no problem.
You know what, I'm gonna need another,
Doesn't need a meeting.
on my desk, it's on my desktop. I need another waiver of jury trial, because I don't have any of those. Well, let me go get it. Well, I don't know if you have to access you have to access my computer.
Oh, okay.
So, yeah.
No problem.
Well,
Your Honor, may I have a moment to speak to?
yeah, absolutely, absolutely. In fact, I'm gonna hold a just brief recess so I can get a copy of a waiver of jury trial. So we stand in recess. Okay, Mr. Cuellar, we're back on the record on State of Texas versus Alfredo Cuellar, 2530884. Mr. Cuellar, you've had a moment to consult with the prosecutor's office and discuss the case a little bit further. Have you decided how you want to proceed, Mr. Cuellar? Okay, what do you want to do now? How do you want to proceed with this case, Mr. Cuellar? Have you come to an agreement with the prosecutor? Do you
Yes.
want to enter into an agreement? Okay,
Uh-huh.
so if you want to enter into an agreement with the prosecutor's office, are you asking the court to withdraw your request for a trial?
Yes.
Okay, so that the record reflect that the defendant, Mr. Cuellar, has requested the court withdraw his request for a bench trial as we were set today. And that's what the court will order, so there will be no further trial matters pending on this case. And is there some type of an agreement that's been reached?
Your Honor, the only thing that the state is offering the defendant is a straight plea to both violations.
Okay, so I guess that basically means, Mr. Cuellar, you either enter a plea of guilty or no contest on the building permit and the construction without inspection. The fines are respectfully set at 220 and 160. Is that correct? Okay, all right. So you have the option, Mr. Cuellar, of entering either a plea of no contest or guilty, and then we'll take up the matter of the fines at that time. How do you want to proceed, Mr. Cuellar, with a plea of guilty or no contest?
Guilty.
Okay, we'll enter a plea of guilty. Let me ask you this before we proceed. Are these going to be, I mean, we're not going to come back to this vicious cycle of Mr. Cuellar pays if he comes back next week because nothing's been remedied.
Right.
For the court's information, Judge, Mr. Cuellar has indicated that he has apparently submitted an application for a variance that would be required for him to get a permit and the inspection. I did let him know that as long as he keeps me informed of the process, any subsequent citations, that application and that process would be taken in mind.
Okay. All right, as long as, I don't want Mr. Cuellar to be kept coming back over here and paying this thing over and over again. It just doesn't make any sense to me. Okay, Mr. Cuellar, so we're going to enter a plea of guilty on both the building code permit and the construction without inspection. Your fine on the code permit, I'm going to lower down from $220 to $100. And your fine on the construction without inspection, I'm going to lower from $160 to $100. So your total fine on both charges will be $200. If you need time to make that payment or make payments, you can make arrangements at the windows to make payment arrangements if you need to do that. All right. Anything else, Mr. Cuellar?
That's all.
All right, Mr. Cuellar, thank you for showing up this morning. Have a good day, sir.
Thank you.
100, 100, 100. Yes, 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 absolutely. Okay. Is there anything else we need to take up?
No, Your Honor.
That's it? All right. All right, thank you, Mr. Cuellar, for showing up. Have a good day, sir. That'll conclude today's docket for the bench trials. They didn't post a bond, right? I don't think so. No, okay.